Hello, everybody. Welcome to our second episode with Allen Overy, your legal guide in a time of crisis. Today, we have the pleasure and the honor to have Maurice Macchi with us. He's Senior Associate at Allen Overy. It's funny because the first time when I reached out to Allen Overy, especially to Natasha Oskian, Natasha, thank you very much for thank you very much. She told us that we were told that you and your team are working 24/7 to serve your clients, especially now during the breakout, during the pandemic. It's fascinating to know in how much you've been able to produce, from a podcast to a report to guidelines, in less than 2 weeks in a record time. We are very pleased to have you with us, and thank you very much for taking your time out of your very, very busy schedule. Thank you, Maurice.
Thanks, Anthony, for this nice introduction, for this kind words, and hello, everybody. This is a first for me to make a webinar, and although I cannot see you, I hope that you and your family are well and safe. It goes without saying that these are exceptional times, and all companies, irrespective of sector or activity, had to find a new way of functioning and had to take decisions rapidly, which necessarily affected not only the operations, but also your employees. In February, I recorded a podcast with my colleague Gabriel Hénard, turning around the employer's rights and obligation in the COVID-19 context. And at that time, we discussed the measures that employers should ideally take for employees coming back from certain regions of Asia that at that time were considered as being at risk, and the potential necessity to put such employees on a quarantine. The impact at that time for Luxembourg-based employers was rather limited and largely manageable.
Okay. Can you still hear Maurice? Hello? Can you still hear Maurice? Oh, he's back.
I cannot hear you, Anthony, though. Yes?
Oh, no, please go ahead, please.
Okay, sorry for that. Yes, I was just saying that the situation dramatically changed as of the 12th of March, when the lockdown has been decided by the Luxembourg government. And since then, you may have seen the press that almost daily new measures are announced and taken by the government to cope with this new situation. And here again, I think it's difficult for many companies to know which measures correspond to what kind of issues, what are the conditions to fulfill, the formalities to undertake, and the deadlines to comply with. And many of you may also wonder whether you could benefit from one of these measures. As labor law specialist, and given as I just mentioned, that the legal framework and the administrative practice changes almost every day, it makes it challenging for us as well to follow all the new rules that are implemented. On the other hand, though, we also got more and more questions over the last days that were indirectly linked to the COVID-19 pandemic, such as holiday planning, for instance, and I will come back to that in a few minutes. So basically, the purpose of this webinar is to give you an overview of all these elements. For the sake of clarity, I suggest dividing the webinar in 3 parts by first differentiating 2 situations. First situation, companies that are still able to operate more or less normally. Second situation, companies, the opposite actually, companies that unfortunately are no longer to operate and are suffering from a reduction of their activities. And then at the end, I will address a few HR issues that I believe are relevant for all of you. So let's start and let's dig into the first situation, companies that are still able to operate normally, or let's say more or less normally. It's fair to say that in that kind of situation, you probably have 3 categories of employees. First, you may have employees that are still working in your premises. And then the question arises whether this is still allowed, and if yes, under which conditions. Second category you likely and most likely have is employees working remotely from home. And third category probably are employees who have taken the special family leave. And I will address this issue, or at least this situation, rapidly as well. So for the first categories of employees, those working in your premises, is this still possible? Obviously, yes, for companies operating in a sector which is considered as vital for the Luxembourg economy, like a supermarket, for instance, that is obvious. But even if this is not the case for your company, you can still ask employees to come to your premises if you are not open to the public. In that situation, nevertheless, you have to comply with several conditions. The first condition, this is actually a general condition that applies even outside of the context of the COVID-19 pandemic, is that you need to protect to the fullest extent the health and safety of your employees. There is no specific guideline that has been taken now by the Luxembourg government for this particular situation, but all the common sense rules that are applicable even outside of the professional world remain applicable in your company as well, meaning that you need to put into place the social distancing measures. You need to put at the disposal of your employees, for instance, hydroalcoholic solutions to wash their hands, maybe even to put at their disposal masks, to reorganize the office, and to take all the necessary measures to protect to the health and safety of your employees. And it's fair to say that if an employee got sick because not the necessary measures have been taken and is able to prove that, a court will most likely be very severe when setting the level of damages in that situation. And I would definitely recommend a prudent approach when asking employees to come to your premises to work. And in that context, I would even recommend to limit the number of employees to a strict minimum, and only to ask employees who are critical for the proper running of your business to come to the premises. And even for those employees, the general recommendation should be to try to split the time between presence at the office on the one hand, and on the other hand, the home office, for instance. One could imagine that the employee only come every second day, or only comes in the morning in the office if this is necessary, but the number and the duration of the employees being present at your premises should be limited to a strict minimum. This is for the first category. The second category are those, as I mentioned, who work remotely from home. And I assume this is the very large majority of your employees. And there are several points of attention that have to be taken into account. So first element I wanted to address, and you may have seen a different position on official websites from the government, for instance, and even in newsletters of other law firms who maybe have a more conservative approach, is that we take the view that there is no legal and practical need to conclude an addendum to the employment contract to implement the fact that the employee now is working from home. Why is that? What is the justification? The justification is basically to say that the agreement that has been concluded almost 10 years ago between social partners about telework foresees that an addendum is needed if one falls under such agreement. And this agreement, if to consider whether you fall under this agreement or not, you should assess whether the teleworking is structural, regular, usual for the employee. If there's kind of pattern, for instance, if you say every employee, or at least an employee works every Friday from home, then you have a pattern, you have a structural telework. Here we are not in such kind of situation. Here we are in exceptional circumstances for a limited period of time. And that's the reason why we believe that no regular structural telework applies. And this leads to the fact that no addendum is needed. And this is the theory, but even from a practical point of view, it is, in my opinion, totally unrealistic to assume that it would have been possible at the moment the lockdown has been decided, that hundreds of addenda could have been prepared from one day to another and signed by the employees. So basically, we remain of the opinion that this is not necessary. However, this does not mean that you should not document the fact that employees work from home. Our recommendation is to send a general email to your employees, reminding them of their obligations, for instance, confidentiality obligation, the use of IT tools, and so on, and also taking position clearly on the working hours while being at home. This is also important to ensure that the coverage, in case of a work-related accidents occurs, that the coverage is guaranteed. So if you have not done yet, recommendation clearly from us is to send such kind of email to your employees. Maybe one word for regulated entities falling under the supervision of the CSSF. Here again, as you know, you should in principle seek an authorization before implementing telework. The CSF has communicated very clearly and said that this is not necessary in the current context, provided, however, that your IT systems are secured. So this is something that has to be checked and taken into account. In particular, if there is an issue, is a data breach or something, it cannot be entirely excluded that the CSF will then maybe pronounce sanctions if there's a problem at a later moment. So this is something that has to be taken into account as well. The question, another point, the question came up over the last days, whether IT tools you would have put at the disposal of your employees, for instance, a laptop, a cell phone, and so on, for the performing of the telework, whether if such IT tools is damaged somehow by an employee, whether an employee could be held liable for that. The answer is actually the same than if this occurred in your offices, in your premises. The answer is no. In principle, this is not possible. There are two exceptions, though. The first exception is there is a gross negligence of the employee, and the second exception is if there is a willful misconduct of the employee. But at the end of the day, it will be difficult, obviously, to prove whether we are in those two exceptions or not. For instance, if an employee takes the iPhone you put at his disposal and throws it against a wall, then obviously it's a willful misconduct and he could be held liable. But you can obviously not prove that he did that if the employee tells you that the iPhone simply slipped out of his hand and fell on the floor. So this is basically the same rules that are applicable then as if the damage occurred in the premises. So in principle, you cannot hold your employees liable for that. Another question we came across several times also over the last days is the question whether you need to continue to grant lunch vouchers to the employees who have the contractual entitlement while the employees are working from home. The answer here is in principle yes. This is a remuneration element. You cannot simply cut it. You have to continue to grant them. However, it is in our opinion possible to find an alternative solution because the employees will most likely not be able to use them, although we all know that some are using it to go to the supermarket, but this is actually not the purpose of it. Nevertheless, from a practical point of view, you may struggle to send all the meal vouchers to your employees by postal mail. So our recommendation is to say, to communicate to the employees now and say, we may deduct that from your net salary as we always do. However, we will hand them to you once we are back in the premises and you can use them at that moment. I think this should not trigger any particular issue from a legal perspective, but you should definitely consider communicating about that in order to avoid any misunderstanding. Last question that we also had several times over the last days is the question of a trial period for an employee who would recently have joined you. Telework still means work, which means that if an employment has already started, in that situation, clearly you cannot amend or extend the trial period that has been foreseen initially by using, for instance, an argumentation saying that you cannot properly assess the performance or the soft skills of the employee while the person works remotely. This is not possible, even if the person would actually agree to it. So this is something that would not be enforceable in front of a court. So we would definitely not recommend it. However, for future employees that are expected to join the coming days and weeks, our recommendation, if the employment contract has not been signed yet, is to consider a sufficiently long trial period to take into account that the first few months, maybe in a worst case scenario, would still be performed remotely. Last but not the least point definitely is the good news, and I'm just mentioning for the sake of completeness. I assume all of you have seen that in the news. There will be no tax or social security disadvantage for cross-border commuters, which means that the days the employees work from home are not taken into account into the usual thresholds, and this is obviously very good news for both employees and for the employers. So this is the second category of your employees for companies still able to operate more or less normally. The third category I mentioned are those benefiting from the special family leave. As you know, the family leave allows one of the parents to stay at home for childcare purposes while being paid by the company, and the company then receives to a large extent the reimbursement from the employer's mutual fund. The government's recommendation in that respect has been to say that the family leave should only be used if there is no other alternative solution for childcare. But on the other hand, the government also said that the employer cannot refuse a request for a special family leave, even if, for instance, the employee has been granted the right to work from home. You can obviously discuss whether the fact for working from home and taking care of the kids at the same time, whether this is possible. In some situations, probably not, in others, maybe. But at the end of the day, given that you cannot refuse it as an employer, the only possibility that remains is to discuss with employees to try to find a solution. For instance, that the person works from home in the morning and takes care of the kids in the afternoon, or the other way around. But at the end of the day, the employee will have the final say and decide whether you want to take that leave or not. However, one important element to mention is that if one of the two parents is in partial unemployment, and I will come back to partial unemployment in a few seconds, then no member of the entire household is allowed to take the family leave. It is for the moment not clear how long employees will remain eligible for this specific family leave. It's fair to assume that it will last until the schools open again, but this will have to be specified and decided by the government. For the sake of good order, I want to stress as well that employees benefiting from the family leave are protected against dismissal, like any other employee that would be on sickness. The legal regime for both leaves are exactly the same. So in principle, you cannot proceed to a dismissal of an employee who takes the special family leave. So this is the first situation I want to speak about, companies that are still able to operate more or less normally. What about companies that unfortunately are suffering from reduction of their activities? There's mainly one tool, I just mentioned it, that are at the disposal of such kind of companies. This is the state-backed partial unemployment system, chômage partiel in French. Two comments first. The government has confirmed that companies that have been ordered to close in the current context are automatically eligible to this partial unemployment system. Companies, however, that have not been ordered to close, but that suffer from reduction, may be eligible as well, but subject to a prior approval, which means that you would then need to do a specific application. There's a dedicated website that has been implemented by the government. You will find that very easily, and you have to provide certain level of information and explain how your activities have been reduced due to the current context. The system of partial unemployment allows companies to put employees that are less busy on partial or total leave. And during this period of leave, the employee does not receive his normal salary, but a specific indemnity, which corresponds to 80% of the normal salary, but which is capped at around 5,300 euros for a full-time leave. The employer is required to pay this indemnity directly to the employees, but then get reimbursement from the Luxembourg state. And as you may see, there is a specific website that has been implemented by the government for this partial unemployment, but some comments were a bit confusing in my opinion. So this comments several comments. The first comment is that if you have recourse to partial unemployment, your entire company will not be allowed to carry out any dismissal for economic reasons. This does not affect only the employees who will actually be in this partial unemployment system, but all of your employees, even those who are working normally will be protected during this period of time. Another comment, which is very important as well, is that, and this has actually been introduced at a bit later moment, that at the end of March, to be more precise, that employees are required to take all their unused, untaken days of holiday of 2019 before being eligible to partial unemployment. This does not concern the days for 2020, but all the days that may remain from 2019 have to be taken first. I have clients that have applied for the unemployment system already in March before this rule has been introduced. The question that came up is whether you should rectify the payslips from March. My recommendation is to say, no, there is no need to do that. The obligation has been implemented at a later moment. So basically you should only ensure that in April now, the days, the holidays that remain from 2019 are used up, and then to put the employees on partial unemployment for the rest of the months. And I assume that this will be accepted by the authorities, given that you would then have complied with the obligation as of the moment you have become aware of it. As I mentioned before, the system is done in a way that 80% of the salary will be paid, but with a cap of 5,300 approximately. This means that an employee will never get more than this amount, even if his normal salary is much higher in reality. Then the question is whether you are actually allowed to pay more, to pay the delta between this indemnity and the normal salary. Here again, the answer is yes. You have this possibility to pay the delta, and we have a number of clients who have done that. In our opinion, though, you should only grant this delta if you get something in return. Then we can maybe discuss or think about what this return would be. Or if the purpose actually to retain employees from leaving, we may be afraid of the current situation, you would say, I will pay the entire salary for retention purposes as well, and to show you that I count on you, you are one of my top talents, and that's the reason why I'm paying the entire salary, even though I would not be obliged to do so. Important comment as well is that partial unemployment cannot be taken at the same time by an employee who is in teleworking. However, the two measures can be taken one after the other. We could, for instance, imagine that an employee would be working from home in the morning and would be on partial unemployment in the afternoon. This is perfectly possible. Likewise, partial unemployment supersedes the employee's right to the special family leave I talked about a few minutes ago. In other words, if an employee has been put in partial unemployment, neither the employee nor the other parent is then eligible to the special family leave. This is obvious because the person who is in partial unemployment should in principle have time to take care of the children, and that's the reason why one cannot be on the special, we cannot take the special leave if one has the right to take the partial, or at least one is eligible for the partial unemployment. This is what I wanted to say about companies who are no longer, unfortunately, able to operate normally. Third and last theme I want to talk about is the HR issues that came up over the last weeks as an indirect consequence of the pandemic. First topic I want to talk about is the holiday planning, as I mentioned, in particular because the Easter holiday is now coming. We have received many requests from clients asking us how to handle situations where employees who have already take holidays or planned holidays for the coming weeks now ask the employer to cancel them. I assume because they have no longer the possibility to travel, and that's the reason why they prefer to be on family leave or on sick leave or another leave, but they do not want to take their ordinary holidays. And this issue is obviously related to a second one, which is how you do the holiday planning generally speaking for this year. Because if you have still employees in July or in August who then have 20 or 25 days of holidays remaining, how you would handle the situation if at that moment your activity starts again and all hands will then be needed. Before answering this question, 3 rules can be repeated. The first one is that except in the partial unemployment situation for the days of 2019, as I just mentioned, you as an employer cannot impose any holidays upon the employees, which means you cannot force them to take any holidays now if the employees do not want to. This is the first element. The second element is holidays granted unilaterally by the employer cannot be unilaterally withdrawn. This means that you cannot cancel holidays of your employees that you already accepted in the past. There's one exception for employees who are vital or critical for the proper running of the business. This is an exception that has been foreseen in the current context, but in my opinion, that should be rather limited in practice. The general rule is that you cannot cancel holidays that you already accepted of your employees. And the pendant to that is to say that employees, on the other hand, can either not cancel holidays that they already have been approved internally, which means that in my example just before, employees that are not able to travel during the Easter holiday cannot cancel those holidays. And you should definitely refuse such kind of requests. I know that some labor unions and staff delegates have another opinion on that, but our recommendation, and this has been backed as well by a case law decision of 2 years ago, that you can refuse this request, and you should definitely do that in writing by sending an email to an employee who would make a request to cancel holidays that have already been granted to him. And you should be very firm on that. And if at the end of the day, I do not expect this to happen, but if at the end of the day, an employee would go to court to challenge this way of proceeding, I'm reasonably confident that there are fair arguments to be put forward and that a judge would consider this as being a valid decision. This, as I mentioned, has also the consequence that an employee cannot switch from ordinary holiday to the special family leave if the holidays has already been granted. Now, as I mentioned before, this is only one part of the problem. The second problem is how you do your holiday planning for the rest of the year. As I said, you cannot impose this to the employees that they take now a certain number of days, but you could already take initiatives to encourage and to maybe incentivize them to take days of holidays now. How could you do that? Obviously, one can be creative and say, if, for instance, an employee accepts by the end of the month to take, for instance, 5 days of holiday, you will then grant him one extra holiday that could be taken at a later moment. This will obviously be linked to a cost factor, but is a possibility. Another possibility is to say that if an employee accepts to take a certain number of days by the end of the month, this person will then have a kind of priority rank for the dates in August, in July, and August, and September. For instance, the person would then have a kind of guarantee that he can then choose the days he wants in July, August, or September, when hopefully all of this and the current situation is behind us. This is something maybe to discuss internally, and also to involve the staff delegates to explain your position to them, and also the need you will then have at the later moment in the year to have the operational stability when your activity starts again. I just wanted also to underline that there could be dramatic and harsh decision that would have been taken if you do not do such planning now, because if you are confronted with a huge lot of application for the same dates for the end of the year, you would then have no other choice but to refuse them, or at least to ask for a postponement on the basis of service needs. And this will probably lead to unhappy employees, staff delegates who will not understand that or will make internal noise. And that's the reason why our recommendation is clearly to say to already plan now the holidays for your entire staff, or for a large part of your staff for the rest of the year. The second topic I want to talk about is dismissals. Here it's relatively easy. All the rules remain applicable, all the classical rules, except, as I mentioned, in case you are in a partial unemployment situation, then there's a protection against economic dismissal. But if we put that aside, all other rules remain normally applicable. Maybe for the sake of good order, we have recommended to clients to do the preliminary interview, dismissal interview via video conference call, for instance. This is only a matter of formalism, and I'm pretty sure that the judge would not question that. all other rules, as I mentioned, remain perfectly applicable. Maybe one question, this brings me actually to the third topic, is how you sign the documents, the dismissal letter or the letter of reasons, or even a settlement agreement you would conclude with an employee to settle the dispute out of court. Obviously, from a theoretical perspective, it is better to have a wet signature. This would give you legal certainty, unless, of course, you have the real secured electronic signature with LuxTrust. But on the basis of my experience, not many companies have that. But in practice, my opinion is that it's in the current context acceptable from a risk perspective to only sign documents electronically, which means you can perfectly use scanned signature, exchange them by email, or use an alternative software like DocuSign. This is possible provided, and this would, in my opinion, reduce dramatically the risk you would have, is that if you have a specific clause in the agreement outlining clearly how the document is signed, then I cannot imagine how an employee would put that into question and say that his electronic signature is not binding on him. So this kind of clause should definitely be foreseen. You should avoid using the standard clause you have and use a specific clause for the current situation. Last topic, but definitely not the least I want to talk about, is the communication internally, in particular with the staff representatives. I think it's important to keep them in the loop about all the specific measures you are about to take or you already took in the past. If employees have questions, they will naturally turn to them and ask them. And if you have already informed them and maybe have their buy-in about the measures you have taken, then it will ease the communication and it will help you through this difficult period. And maybe a last recommendation is to say it's, in my opinion, already important to discuss and to consider with them today's situation post-lockdown. What kind of health and safety measures you may need to implement at that moment? What about the holiday planning, as I just mentioned? And what about generalizing the more flexible, agile way of working we are all experiencing today? This is something that would show that you have, to a certain extent, or if I may say so, learn a lesson from the current crisis. And if you already come up with these topics today, this will most likely help when the activity starts, that all of your employees are happy and that they will understand maybe some decisions you will have to take that might be more difficult. So this is all from my side. Thank you for having listened until that moment, and I would hand back to Anthony. Thank you.
Thank you very much, Maurice. Unfortunately, we won't be able to take questions, but where can the audience find you if they want to reach out?
Yes, if there's any question, do not hesitate to drop me an email. I'm of course happy to help. You will find my contact details on alhenovery.com and on LinkedIn. Thank you very much. I wish you all a happy Easter break and stay safe.
Thank you, Maurice. Thank you.
Thanks.
Good day to you as well. Bye-bye.
Bye.